Hello, and welcome to today's webinar, Clean Water, Lessons Learned from the Supreme Court's Maui decision. I'm Brian Gum, the Communications Director at the Center for Progressive Reform. CPR is a think and do tank with a network of more than 60 member scholars working to build thriving communities on a resilient planet. We drive policy reform with rigorous and accessible legal analysis designed for changemakers. I'm now going to turn things over to Rob Verchik, CPR's board president and today's moderator.
Thanks, Brian. Hi, everybody. And thanks, everyone, for joining us today in this last week of May. I'm Rob Verchik at CPR and also a law professor at Loyola University, New Orleans. But I'm speaking today from Washington State. Our topic is clean water, specifically lessons learned from the recent Supreme Court decision, County of Maui v. Hawaii Wildlife Fund. In that case, local clean water advocates argued that a wastewater treatment plant needed a federal permit before it could pump sewage into the ground that was going to filter into the ocean. Those advocates won in this case, and the court's decision might have broader implications for environmental protection, for regulatory law, as well as for science and also for community activism. This is also a case for the lawyers in the audience about the word from, okay? So we're gonna get analogies about grocery shopping and spiking the punch bowl and all kinds of things. But I'm gonna, first of all, just tell you we have a terrific group of guests today. Everybody on our panel contributed to this case, to the plaintiff's side, in a significant way. And so I'm just going to go ahead and introduce people first. Then we're going to have a discussion of maybe about 40 minutes or so. And then I am going to open up the Zoom room for questions. You can put your questions in the Zoom feature on Q&A and just keep banking them, and I'll be looking at them. And after the discussion, we'll get to those. And so let's just go ahead and get started. Let me tell you who we have today. We have Hannah Bernard. She's the executive director and co-founder of Hawaii Wildlife Fund. She has spent 12 years of her career organizing and advocating around this particular case. And she's joining us from the island of Maui today. David Henkin is the staff attorney for Earthjustice, based in this Office of Earthjustice, based in Honolulu. He argued the case before the Supreme Court. He has lived in Hawaii for many years, but he is from California. That's a joke that you'll hopefully get after we talk about all this. Amanda Leiter is up next. She's with the Center for Progressive Reform. She's one of our member scholars, and she's a law professor at American University. She co-authored the brief with David Henkin and other lawyers. And then finally, I want to welcome Steph. She is also a CPR member scholar. She's a law professor at the University of Wisconsin. She co-authored a friend of the court brief in this case, representing aquatic scientists. They were advocating for a science-based resolution to this dispute. And in oral argument, Justice Breyer called them all geniuses. That's true, all right? So welcome, everybody. And just to start things off, Amanda, I want to turn to you. Can you just set us up and briefly explain the dispute in the Maui case and how the court held, and maybe why this is important for us to be talking about today?
You're on mute, Amanda.
You'd think after teaching on Zoom for an entire half a semester, I would have figured this out, but
it happens.
Not. The map that you see in front of you shows the basic layout of what was happening on the island of Maui. The 4 colored dots in the upper right corner are injection wells. And basically the County of Maui was injecting about 4 million gallons per day of treated sewage into those wells. The treated sewage was seeping into the groundwater at the bottom of the wells. That was, in fact, the intent of injecting it there. And the groundwater was flowing quite predictably downhill toward the beach, and as you will hear later from David, coming out in an offshore reef. The question that was presented in the case is whether the county could go ahead and continue to do this without a Clean Water Act permit under what's known as the National Pollution Discharge Elimination System program in the Clean Water Act. That program essentially requires permits for any discharge from a point source to navigable waters. It was very clear to everyone and essentially admitted by everyone that if the county was instead discharging all of this treated sewage through pipes directly into the ocean water, they absolutely would require a permit. And of course, it's important to keep in mind that it's not just a piece of paper. The permit is also the sort of control point at which the state and the federal government can require pollution mitigation. So if they were discharging directly into the offshore Pacific, excuse my dog, then they would have needed a permit. The question here was whether if they're discharging instead into groundwater and the groundwater then flows into the offshore Pacific, do they need a permit for that activity? The county's position was that any discharge that flows through groundwater before it reaches navigable waters does not require a permit. EPA had flip-flopped a little bit. Their long-standing position is that this kind of discharge does require a permit, but in this case, they issued a sort of interpretive guidance saying that instead, essentially, if pollution flows through groundwater to the navigable water, no permit is required. The Supreme Court ruled for the respondents here and said essentially that an indirect discharge, even if it flows through groundwater, does require a permit as long as it is functionally equivalent to a direct discharge to navigable waters. And I think we'll hear from Steph later about exactly what that functional equivalence test looks like, but it's a test that's informed by science. It's going to be very ad hoc and specific to the circumstances of particular discharges. So this was a win, in my view, for respondents, although the court did remand the case back to the Ninth Circuit to assess whether this particular discharge is in fact the functional equivalent of a direct discharge to the Pacific.
Thanks. Hannah, I want to bring you in. This treatment plant, this wastewater treatment plant, it had been around for a long time and it had never had a permit. And I'm assuming that people knew around this community what was happening. That is that this sewage was going into injection wells and then eventually finding itself into the ocean. How did this dispute get your attention with your organization? And how did the communities decide to come together and then decide to bring a lawsuit?
Yeah, well, the way that we got involved was because we are on an island. We can see immediately what's going on in the nearshore waters. And all of us who live near the water, whose livelihood depends on it, way of life, quality of life, we noticed the changes. Since I moved here in 1991, I lived through the decline of that reef, and that was the receiving waters for the injection wells, and watched it begin to die. And so it wasn't that we needed a scientist to tell us, although I am trained as a marine biologist, that the reef was in trouble and not doing well, but we certainly did begin the process of listening to our scientific community there on Maui, who were starting to do studies as early as the 90s to look at what was going on with the health of the reef. And as soon as the data started to come in, that there was a correlation between these injection wells and massive macroalgae blooms and degradation of the reef, dying of the corals, that's when we all began to start getting very concerned about maybe it really is the injection wells. There was always the suspicion. And in fact, as David will probably speak to in a few minutes, There was absolute knowledge that there was a high likelihood that the reef could be impacted in the future, 10 or 20 years after their installation. But we saw this with our own eyes, and then our scientific community began to collect the evidence. So we worked with our communities. Our communities surfaced the problem. It's those of us who love the ocean, brought it to the attention of those of us whose livelihood is the ocean. And then we began to work with collaborators. So the co-plaintiffs in the group, Surfriders, Sierra Club, West Maui Preservation Association, were all community-based organizations, and so is Hawaii Wildlife Fund, the one I'm the director of. And then we began to organize our community to see what we could do. Could we do anything? Could we, do we have any nexus for involvement? And yet there was a permit. It was the underground injection control permit, and it was up for review. So at that point, we began to work with our next level of helpers, our advisors, not just the scientific community, but regulators, the agencies, EPA. We had help from the EPA at that time. They were very favorably predisposed toward supporting us to getting a better permit in place, and understanding that we would very likely need to move beyond just the UIC. And so we began to get the momentum rolling with collaborators, advisors, community groups working with our county, and that's when we began negotiations. After 4 years of fruitless negotiations, getting nowhere, and demonstrating and being very clear about the legal liability to the county at this point in time, all the way up until 2008, we still couldn't get anywhere. 4 more years went by, and that's when we had to turn to our defenders, and that's Earthjustice. So Earthjustice in becoming involved and supporting us to file the lawsuit, that's when we really began to see some movement forward and feel like we were actually on the right road. Little did we know that our path would lead us all the way to the US Supreme Court. In fact, when I started getting the calls from reporters and our attorneys the morning of April 23rd to let us know that the case had been decided in our favor, my first feeling was such deep relief for the rest of the nation's waters, not just ours. Although I have deep personal ties to that reef and this place, but to know that our case now wasn't going to blow a hole in the Clean Water Act, and now the Clean Water Act was being ruled in favor of, incredible feeling of exultation for all of us in the community. And you can see some of the photos here are different parts of our community groups coming together at various council meetings. Our county council was very favorably predisposed towards supporting us to withdraw the case from the Supreme Court's jurisdiction when the mayor decided to go ahead and take it forward. So a huge victory for us in the community, long time coming, 12 years of serious involvement, at least in Hawaii Wildlife Fund in my case, and many others of us in the community for many years before that.
So this is great. I'm loving looking at all of these people here from, and I assume these are people from the community, from the science community too, and others. Can you say just a little bit about the what's at stake? I mean, what's significant about this particular reef? This reef I know is near Lahaina in West Maui, and that is a heavily touristed area, I'm sure.
Absolutely, yeah.
So what is it? Tell me about the reef that makes it so special and makes this issue so important in this case.
So this reef is called Ha'enanui Reef. That is the name in Olelo, Hawaii. And then there's a beach park right adjacent to it called Kahekili. And this is one of our most important recreational sites on West Maui. I was living on West Maui myself in the 90s and raising my sons, accessing that reef, enjoying the beauty. My friends and family fed themselves off that reef. It's now received protected status, so it's being managed as an herbivore recovery zone, because the deal in our Department of Land and Natural Resources here in Hawaii is trying to also help give the reef an additional break from loss of herbivores to keep the algae from overgrowing. But as you can also see in this slide, you know, it once was a beautiful, pristine reef. And in fact, it certainly was in the early 90s when I first was accessing it myself. And then you'll see that in the bottom photo. In the top photo, that shows you one of those zones where the seeps are. And there's these underwater springs, and seeps of the treated wastewater are gushing out, and those bubbles are indicative of the seep right there. So
and this sewage that's coming out, this is the issue, right? Is that those are nutrients, phosphorus and
right,
and
so
nitrogen and so on.
Correct. It's treated
Yeah.
wastewater. So and
That's creating algae, which is harmful
Yeah.
to the ecosystem.
Yeah, the nitrogen in particular, it's super rich in nitrogen, and that's like that's yum yum mega vitamins for the algae, for the seaweed. So these little turf algae that live right there, you can see the short greenish color all over the reef there. That's going through an overbloom. That's an overpopulation of those types of algae in response to all those nutrients, especially the nitrogen that's coming from the treated wastewater. So the treated wastewater also has a witch's brew of other toxic chemicals. It's got flame retardants. It's been found to have anti-seizure medication, antibiotics, all kinds of
Right.
indicators of human wastewater. So not only is it bad for the reef, but it's not something that I feel too good about swimming in or would recommend for visitors. And it is very important to our visitor industry. This is what our economy is based on, is tourism. And so, like it or not, it's our primary economic engine. And we can't possibly imagine the loss to our income, let alone to our way of life, and for many people, their food on the table, for losing the biodiversity and the health of a reef, like you see right here in these slides.
David, I want to bring you in to talk a little bit about the legal issue. Amanda, excuse me, Amanda mentioned that this is really about whether or not these injection wells, which are understood as being something called point sources, whether they require permits under the Clean Water Act, and that has to do with whether or not this sewage is coming from the point source, that is the injection well, or is it instead coming from the groundwater, right after it's already been injected into the well. And so this question, I mean, it's odd in a way to review the history of this case, or at least a transcript of the oral argument, that this is really kind of about a grammar lesson or a discussion about what it means to be from something. And as I said earlier, there were different analogies. The Deputy Solicitor General says, well, if you pour whiskey from a bottle and then the whiskey goes into a flask, and then you take the flask to a party and then pour the whiskey into a punch bowl, you wouldn't say that the whiskey got into the punch bowl from the bottle. You'd say it came in from the flask. And then you said, well, if you're getting groceries and bringing them into the house, you wouldn't say that you got the groceries from your car. You'd say you got the groceries from the supermarket. And so in a way, this is like an incredibly kind of simple idea, what it means to be from something else. But the court also had real questions about like what the limit would possibly be, because everything is connected to everything else, and almost any drop of water can end up somewhere else at some point. How did you see this issue? What did the EPA's original viewpoint look like? How did it change, and how did you see your role in terms of making the court feel comfortable with a rule that would have some limits around it, but achieve the purpose that you thought the Clean Air Act intended?
Well, I think, Rob, the first thing, you're right that to some extent this is a case all about the word from, but it's a discussion and an analysis of what from means in a particular context. And what was particularly refreshing and just happy to see in the Supreme Court's decision is that they understood that this wasn't some sort of abstract debate. And just let's reflect for a minute on the photos that are currently being shown about the upper portion being the reef that's being affected by the injected wastewater, and the lower portion being the reef that's not. And think about this in the context of the Clean Water Act, whose declared purpose is to protect the biological, physical, and chemical integrity of our nation's waters. And if you're used to the lower portion of the reef, the lower picture being what the reef looked like before these injection wells went in, and to be clear, this is this is still what parts of the reef look like, the parts that are up current of the injection. But then you look at the upper picture and you see what's happened to the physical, chemical, and biological integrity of the reef. And from a Clean Water Act perspective, you got to know that something's wrong. So if we could go to the next slide. So basically what the County of Maui did when it built this facility, as Amanda mentioned, they acknowledged that if they had done like what many coastal communities do and built a deep ocean outfall to dispose of their waste. So basically there was a pipe, which is a point source going directly into the ocean. They acknowledged they would have needed a Clean Water Act permit. What they did instead when they designed the facility is they drilled these deep injection wells going about 200 feet down to go directly into the groundwater. This is not your backyard septic system. This is not something where you have small quantities of wastewater percolating through the soil, which is cleansing it as it goes through the soil with bacterial action. And then eventually, hopefully, if it's properly designed, pure water entering the groundwater. What you've got is, this is a facility designed to dispose of, not to store, but to dispose of up to 9 million gallons of wastewater per day. Its actual discharges around about an average of 4 million gallons per day. And they're trying to get rid of it. And the way they were trying to get rid of it is into the ocean. They knew that if they designed it this way, they would hit deep groundwater and it would flow into the ocean. And that was, they did an environmental impact statement in the 70s, about 10 years before they actually built and put the facility into operation. That was always the plan, disposal into the ocean via the groundwater. You asked about the EPA's position. Well, the EPA for, going back, this is not a recent interpretation. This goes back at least until the early 90s under George Bush the first. EPA was repeatedly saying in Federal Register notices that you don't get around the Clean Water Act by discharging via hydrologically connected groundwater, that we're not regulating the quality of the groundwater. That's not the ambit or the scope of the Clean Water Act. We're regulating the quality of the surface waters that these pollutants get to. And so in the Ninth Circuit, the EPA, consistent with its longstanding, 30, 40-year-old position, filed a friend of the court brief in support of our position that this facility needs a Clean Water Act permit. Because as the Ninth Circuit then noted in its opinion, that it would make a mockery of the prohibitions of the Clean Water Act if the county could do indirectly, i.e. through the groundwater, what it couldn't do directly, which is pollute with abandon without any regulation, without any controls. And so that's exactly what was happening. Now, as Amanda correctly noted, the county wasn't going to take it laying down from the Ninth Circuit, so they appealed it to the Supreme Court. And they took the very extreme position that discharges via not only groundwater, they also said that if the pipe stopped 5 feet short of the shoreline and the pollution flowed over the surface of the ground, that would somehow be non-point source pollution because the ground is not a point source. I mean, it went to levels that clearly gave at least 6 justices extreme pause. So let's go to the next slide and see what kind of information we had in this case that just made it clear that this was accomplishing the same thing indirectly that was prohibited directly. So this is a picture of someone working on a tracer dye study that was funded by EPA, and it was carried out largely by researchers from the University of Hawaii at Manoa, where they were pouring in fluorescein dye into the injection wells because they wanted to see how quickly, whether people's hunches that all of this damage to the reef were being caused by the nutrient load being added by the injection wells. So they poured this dye in, and this type of dye, just to be clear, it's a fluorescein dye that scientists, and Steph maybe will speak to this, they have very, very sophisticated instrumentation to be able to detect parts per billion that the human eye could never see. They were good. So they then went and monitored these devastated areas of the reef, waiting to see if these sensitive instruments could pick up a part per billion of this dye. Let's go to the next slide and start the animation. This is now, we're going to be seeing a video that was taken this is now in that reef. And if you can see this green Kool-Aid that's coming out of the reef, that's the fluorescein dye. And this is not this is not a video taken with fancy instrumentation. This was visible with the human eye, that you could see green Kool-Aid coming out of the reef. That's how direct the connection was, the hydrologic connection was. And with this evidence, the scientists who did the study were able to determine that in fact, people's hunches were correct, that the hydrologic connection, basically the pollutants traveled a distance of half a mile through the groundwater. The first pollution hit the ocean about 84 days after it entered the injection wells, and with an average transit time of about 14 to 16 months. So if we could go to the next slide. This is, the Supreme Court was going in the other direction. Yeah, the Supreme Court was concerned that the Ninth Circuit had articulated a test that focused on language that said, if it's fairly traceable, then you need a Clean Water Act permit. And they really myopically narrowed in on this term, fairly traceable. And they were concerned that, heck, scientists can trace anything. And that would be a very broad ambit to the Clean Water Act and would capture all sorts of activity that no one would consider to be the types of things that Congress was trying to regulate. What the Supreme Court majority didn't look at was actually the full thing that the Ninth Circuit said, which is the functional, it said fairly traceable such that it is the functional equivalent of a discharge. So, when the Supreme Court articulated this new standard, functional equivalent of a direct discharge, is actually very akin to what the Ninth Circuit panel applied. But in any event, the Supreme Court articulated this test that we're not going to allow people to evade the Clean Water Act by doing indirectly what would be prohibited directly, as long as it's a functional equivalent. And they used a very common sense approach to that focused on the statutory purpose. Congress was trying to regulate identifiable point sources of pollution that are degrading the quality of our surface waters, like the ocean at Lahaina, where we knew it was due to the injection wells. They identified a bunch of different factors and then highlighted that transit time and distance traveled in most cases are going to be the determinative ones. And they also set up some goalposts in the opinion. So they said, if a polluter cuts its pipe off a few feet short of the water's edge and it goes through a little groundwater and rapidly gets into the neighboring surface water, then of course a permit's needed. And then I think very significantly at the other end of the goalpost, it said, if the pipe cuts off 50 miles away from the surface water and it takes many, many years, then a permit likely, and I think the fact that the court qualified it by saying likely would not be needed rather than absolutely wouldn't be needed, made it clear that they really wanted, they don't want to undermine congressional purpose in protecting surface waters from discharges even through groundwater. And in our case, because we have this tracer dye study, we know the transit time is 84 days, not many, many years. And we know the distance traveled is about half a mile, not 50 miles. So we're pretty comfortable that it's just been remanded to the Ninth Circuit. It's going back to the same panel, or at least it should be under Ninth Circuit rules, same panel that found it the functional equivalent before. And so we're pretty confident that we're going to do some good for the water quality in Lahaina and in West Maui in this case.
Great work. Steph, I want to ask you about the scientists that you were representing. You're a trained scientist yourself. And I said in the beginning, Justin Breyer called you all geniuses, which he did, but perhaps not in a way that helped your case, I think, because his point was that that you all have so much technology, you can trace almost anything, and that there might not be any limits as to how far this would go. And one of the things I think in your brief that you did so well was to explain what the different, not only what the different methods of tracing a pollutant are, but what the physical limitations or technological limitations of that tracing. In other words, that there might be limitations built into the technology itself. Can you just say a little bit about when you went in to represent scientists as a lawyer, what is it that the scientists were concerned about? What were their interests? And how did you figure out how to build their interests into a legal argument? That is, how did you try to convince the court that science was relevant here, and that in particular the interests of these scientists was relevant here?
Yeah, so I was lucky enough to be able to represent, in collaboration with Royal Gardner et al. From Stetson Law, 11 hydrological societies and also 4 individual scientists who actually helped us significantly with drafting the sort of scientific text to the brief. Their interests were really just making sure that the court understood the science. They had seen many times in previous Clean Water Act cases when the Supreme Court just didn't get how groundwater worked or anything really. So that was the main focus, was just to communicate how science works, explain to the court that it's not magic, explain to the court that a lot of these kinds of tests, both the tracer tests, the modeling and stuff, is based upon years and years of research and complete testing with empirical observations. So we focused our brief on that. So partly we focused not on just communicating what the science is, but how the science was developed. And honestly, even though the scientists wanted to write in support of the fairly traceable test, really everything that's contained, as David observed, in the functional equivalent test was really what we tried to bring across, right? We talked about transit time and distance traveled, but we also talked about, the different types of groundwater materials through which groundwater moves, also, different pressure points. And you can, I guess if we move to the different slides, if you can go to the next slide, and then also flash through the slide after that. These are the slides by which we try to communicate the complications of tracing groundwater, showing again the limitations that you were talking about, but also how this can be done using science that is based on both modeling and empirical testing.
And these are images that were in the brief itself, just so the audience knows. These perched, well, I learned about perched aquifers and all the different kinds there.
Yeah, it turns out that, different pressure points, the elevation of aquifers can lead to different pressure, which in turn sort of changes the speed at which pollutants can travel through groundwater.
Do you think that as technology improves and as the genius capacity of hydrologists and others improves, that this is in a way a moving target, what the standard is when we're talking about traceability? Or are there non-scientific judgments you think that will help contain this?
Well, I think, the functional equivalent test will to some extent contain this. To the extent that the sort of increasing technology to trace pollutants might lead to the broadening of the Clean Water Act. Maybe part of it is that these things should have been contained, right? These things should have been included as functional equivalents. So I think that's going to be a policy call in the long run. But at the same time, there are also, hydrologists aware that there are limitations in terms of traceability. There's sometimes findings that different aquifers are simply not connected to each other, and therefore, traceability doesn't even matter. So I think that although, yes, there is a concern this is some kind of unlimited sort of test, in reality, not all groundwaters are connected to each other. And the finding will be that despite technological advances, you might just not be able to trace connections between 2 different aquifers.
Amanda, I want to ask you about some of the implications of this case. You worked, as I said, on the brief for respondents as well. And you and I, as does Steph, we all teach about administrative law and sort of what the long game is in this area. And so I'm going to ask you a couple things. When I first read this, when I first read about the decision being released, there were a lot of people really excited on the environmentalist side saying, oh, you've got 6 justices here who are not just reading the text, as David has said, not just saying, oh, what does the word from mean? Let's look it up in the dictionary. They're actually saying, oh, let's look at the purpose of the act. Let's look at the structure of the act. Let's look at the intent that Congress had when it passed the act. And let's use all of these things to help us understand practically, functionally, how we protect the nation's waters. And that's a way of interpreting statutes that that I think it's safe to say has kind of waned in the Supreme Court of recent times. And so many people were saying, oh, well, maybe this isn't just about an abstract discussion. Maybe they really get environmentalism, and maybe the court is really going to start pushing in this area. And that might mean that coal ash ponds, which also leak into the groundwater, might be caught in this net. It might mean that manure lagoons and feedlots might be caught in the net, that mine tailings and flowing into groundwater or on the surface might get in there. I guess I'm just wondering, what do you think we can, in terms of reading the tea leaves, what does this case mean and what doesn't it mean for the future, both in terms of the general idea of environmental protection and statute reading, and also in terms of these other kinds of potential point sources, coal ash, manure lagoons, and so on?
So I have a variety of thoughts on that subject.
It was a long question.
The first is that the case was enormously important, first of all, in terms of its downside risk. So a loss here would have been enormously significant. I think I misspoke when I was introducing initially the petitioner's position. They really were taking the very extreme position that the NPDES permitting requirement that I described at the outset, this Clean Water Act requirement that you get a permit for any discharge from a point source to navigable waters, only applied, in their view, if the point source discharged directly into the navigable water. And as David pointed out, David, by the way, has lost his internet. He just texted me. So hopefully we'll get him back shortly. But as David pointed out, that would mean, and this was in our brief and it was discussed in oral argument, that would mean that you could, that it would be a recipe for any polluter who wanted to figure out how to evade the program, right? Just cut your point source pipe 5 feet short of the river, and suddenly under the petitioner's interpretation, you wouldn't need a permit. So the first really significant and important sort of implication of this case is that that is not the rule. We do not have a rule that basically gives polluters or industry a recipe for how to evade the NPDES permitting requirement. And likewise, it's not enough just to point your pipe into the ground and discharge into the groundwater. Because if your discharge is the functional equivalent of a direct discharge, you still do need a permit. So from the point of view of what the downside risk was, I think the win is enormously important. In terms of what it means going forward for the kinds of other cases that you identified, my answer is a little more mixed. So in order to require a point source permit, the entity that is pushing for permitting has to be able to establish that the pollution, it has to be pollution, it has to be coming from a point source, and it has to be going to navigable waters. And for those of you who've been following this space over the Trump administration, there have been some efforts to narrow both categories. So efforts in the court to narrow the categories of what are point sources, and then even more extreme, in my view, efforts on the regulatory side to narrow what are navigable waters or waters of the US, such that if now, for example, you could establish that there was the functional equivalent of a direct discharge into a wetland, but the wetland was not itself directly and easily connected to surface, to a surface river, for example, it would now be harder under the Trump administration's definition of navigable waters or waters of the US, harder to show that that discharge required a permit. So huge downside risk avoided, but in terms of the upside, it's going to depend a little bit on the fate of the waters of the US rule and, you know, the next election and other things going forward in terms of how broadly EPA wants to push its permitting authority.
You know, it's interesting you mentioned the waters of the U.S. because the string of cases starting with Bayview and then moving forward had a kind of a similar trend. Bayview being a case where the court, I think it was Justice White, seemed very interested in the functionality and sort of the scientific nature of how the ecology worked with wetlands. And then as the cases moved on with a more conservative court, it began to be more like just interpreting words in a statute relieved of its context. One question before I let you go, Amanda, from one of our listeners wants to know about how this functional equivalent test might apply to air emissions. Like, what if you're talking about a crop duster or some kind of an instrument that's putting pollution out into the air, and then through the air it's eventually conveyed to a water surface?
That's a very interesting question. My understanding, and I've looked at a few of these cases, is that courts have done something sort of like this analysis, in the sense that they've said if it's a crop duster and it is spraying pollutants directly over a lake so that you know for sure that the pollutants are going to fall directly down into the lake, we will treat that as a point source discharge to a navigable water.
And there are general permits for that too.
And then there are general permits, right? Which is a whole question that we didn't even open up.
Sure, yeah. Let's keep it closed. Okay.
No, it's fine. I mean, the court does say, so there was some concern in the discussion in David's argument around what happens if the test that we adopt then applies to things like septic systems. And David's, I think, very good answer was, well, those are things that EPA could cover with general permitting. The fact of that conversation, I think, helps explain why you get some unusual bedfellows in the actual decision, because some of the justices who sign on to the majority opinion, I think, are quite eager to emphasize that EPA can address the permitting requirement for some sort of broad swaths of industry with general permitting, which is something that this administration has pushed. But the fact of requiring a general permit is not the same as saying the Clean Water Act doesn't apply, right? Even for a general permit, the general permitting programs include pollution mitigation efforts, right? You're not covered under a septic system general permit or a crop dusting general permit unless you comply with certain minimum standards for what that activity is, right? And if you exceed those minimum standards, then you're not covered and you could be liable for failing to obtain a permit. I'm not sure I answered your question.
No, that's good. Steph, I want to bring you in because there's another question here that's, and for those of you watching, we've moved into the question and answer part now. But there's another question about the relationship. This occurred to me and I want to know the answer. What's the connection between this functional equivalent test and the significant nexus test formulated in the Rapanos case, which involves waters of the United States? That is, are these both ways of quote unquote looking at functionality? And is there a way that science can help us understand how to interpret both of these things?
I mean, my own personal belief is there is, and that's where I was going to jump in when Amanda was talking about the Waters of the United States rule that's coming out under this administration. They say there, groundwater doesn't matter. There's a number of elements in there where they say groundwater doesn't matter. They put out this sort of rule, the final rule, right before Maui came out, which is, you know, we figure good timing because now we can, people who are challenging the Waters of the United States rule from this administration can bring up Maui and say, you know, look, groundwater does matter. What the court will say about it, whether or not, you know, the significant nexus is similar to the functional equivalent kind of test, is going to be up to courts. But, you know, there's people who will definitely push that angle, and I'm on that side.
Yeah. I want to bring politics into this, and that means Hannah and David in particular. One of the attendees is asking, the question I'll just read, would you still settle the case on the same terms the Maui County Council approved in 2019 if the mayor and the council made that offer today? And I ask that because I know there were a lot of sort of interesting political maneuvers happening in this case. Hannah, do you want to Well, I don't know which of you probably is more interested in answering that, but I'll give Hannah the choice, and then you can defer to David if you want.
I definitely would defer to David because absolutely our council has been amazing this whole time. I just can't speak highly enough of the value of having these extraordinary attorneys defending us, the best in the world. And as one of 4 co-plaintiff groups, anything that we do, we work together on. So I would be reluctant to speak as an individual plaintiff representative without first consulting with our attorney and the others. So I'll let David take this.
Thank you, Hannah. Excellent, excellent illustration of the good collaboration between public interest advocates. For those who are watching who might be wondering what is the terms of the 2019 settlement offer, to be clear, the council and frankly, I think everyone concerned about clean water in the country were concerned about what the Supreme Court might do with this particular case if they had adopted the extreme position of the county that, you know, pipes cut 5 feet short from the shoreline can pollute with complete abandon, and the Clean Water Act has nothing to say about it. Obviously, that would, as the court observed, blow a huge hole in the Clean Water Act. So the terms of that 2019 agreement were if the county were to drop its appeal to the Supreme Court such that the Supreme Court would not reach the question and we would stick with the Ninth Circuit's holding, then you know, we would just go on and we'd focus on fixing the problem. And the problem here is quite fixable because while this injected wastewater is death to the reef, it's a valuable resource in very arid West Maui and can be used as it was historically for agriculture, for watering golf courses, for resort landscaping, and basically put to beneficial use. So, so that deal, the 2019 deal, obviously the quid pro quo is no longer there because they did not drop their appeal to the Supreme Court. So we can't, you know, that deal just doesn't exist anymore. But the basic thing, which is, as Hannah mentioned, for 4 years before going to federal court to enforce the Clean Water Act, Earthjustice and the citizen groups worked together to try and convince Maui to focus on fixing the problem in the way that I suggested, which is reuse rather than inject. And we continue to be committed to that as a solution. So we would be thrilled if Maui County decided to stop spending millions of dollars on lawyers to fight this, what we believe to be a losing battle. Again, both, if you read the beginning of this Supreme Court opinion, it is telling that the Supreme Court itself, the majority notes that first the district court and then the Court of Appeals determined that these were functional equivalents of direct discharges. Now they've remanded for the lower courts to decide if they're functional equivalents of direct discharges. I think we see where this case is going. So rather than spend more time in court, let's spend more time on solutions. So that deal's still on the table.
Hey, David, this is a question coming from somebody, but I want to, it's on my mind too. Were you surprised how the justices ruled? Were you surprised by the lineup of the justices?
Well, I think it, you know, you never want to read too much into an argument, but based on the argument, it was very, very clear where some of the justices were likely to come down. I particularly appreciated Justice Sotomayor during the county's rebuttal, looking at the county's lawyer and saying, how are you getting away with this? I viewed that as a good sign, so I wasn't too surprised to see her on our side of the column. And then with Justice Breyer, he seemed troubled with the Ninth Circuit's test, but super troubled with the notion that the county could do what it's doing and evade the Clean Water Act. So basically, we were really looking to see whether Chief Justice Roberts or Justice Kavanaugh would come our way based on their questioning. They too seemed troubled by the county and the EPA's positions here. And so, you know, I left that argument feeling optimistic that we might be able to peel off a fifth vote. I can't tell you that I ever in my wildest dreams thought that we'd get six votes. So when I saw that, and for folks who don't pay attention to time zones the way we do in Hawaii, Supreme Court issues its opinions at 4 a.m. Hawaii time. So it was bright and early on April 23rd when I opened up this 1 day late Earth Day present. It was a huge thrill to see that. And I do want to highlight a couple of things that Amanda started touching on. We have a 6-member majority, not a fractured Rapanos type decision where we're trying to read the tea leaves. We have 6 justices who joined in its entirety the majority opinion. And not only were they rejecting calls to gut the Clean Water Act, but they also rejected these sort of conservative industry talking points about, you know, how burdensome it is to be regulated and have to get a permit to make sure you're not polluting the environment. And if you make one mistake, then you're going to suffer under these crushing civil penalties of $50,000 per day. And that a 6-member majority of this court squarely rejected both of those. First, they said, as far as regulation, hey, there are these tools that are available, like these general permits to regulate categories of activities that are very similar. And as Amanda mentioned, to make sure that people do the things that need to be done in carrying out those regular activities that aren't going to be harmful. And then if someone makes an honest mistake, if they didn't think that they needed a permit, the court showed great faith in the lower courts, in the district courts, to administer the act consistent with Congress's instructions that before you throw the book at someone with penalties, you look at what were their good faith efforts to comply with the law, and whether a penalty would enact too heavy a burden on someone economically. And they basically said, we trust our lower courts to tailor the penalty to fit the violation. And both of those things, if you've read other older Supreme Court decisions on the Clean Water Act and other regulatory statutes, where they sort of wave around the burden of permitting and the threat of fines as a justification for giving a narrow reading to the law, this 6-member majority didn't do that. And for me, that leaves me very optimistic for future cases coming up to this court.
Okay, so I'm hearing from some lawyers and law professors here who are always, looking at the glass half empty. So I'm gonna send this over to Steph here, I think. And there are a few questions asking basically the same thing. I get everything you're saying, David, but in oral argument and in a concurrence, Kavanaugh goes out of his way, right, to say, oh, this is all consistent with the Rapanos decision, which of course, well, not the Rapanos decision, but specifically Justice Scalia's opinion in the Rapanos decision, which is related to waters of the United States and a narrow understanding of what the waters of the United States would be. And then I will just sort of pile on a little bit and say that I was struck by a decision that Alito made, of course, Alito dissenting, but sort of going out of his way to talk about the Commerce Clause and why that might be relevant to understanding this issue. And so, Steph, I just pitch it to you. I mean, does this discussion about the Commerce Clause from Alito, and second, this signaling from Kavanaugh, even though he's in the majority, that he's on board with Scalia, does this bode in a negative way toward what we might think the court might do in looking at waters of the United States and specifically issues of wetland jurisdiction?
So the Kavanaugh one, when he mentioned Scalia, actually the first thing I thought about was not Rapanos, but more Scalia's concurrence in Decker, if you remember, which was the sort of silvicultural case and whether or not something counts as conveyance. And weirdly, Scalia was the one person, despite all the other justices, who was like, yeah, seems like a conveyance, demonstrated conveyance. And so, although yes, he talked about it in light of Rapanos, I thought that Kavanaugh's conclusion was really consistent with Scalia's conclusion in Decker. What that means for Clean Water Act, future Clean Water Act cases, not totally sure. As for the Commerce Clause thing, yes, I'm concerned about that, and I think that there, depending on the composition of the court, the next time a significant Clean Water Act Commerce Clause case arises, or any Commerce Clause cases, we've talked about the Endangered Species Act type Commerce Clause cases, we'll have to see what happens. I think that's just signaling at this point towards a sort of more limited interpretation of the Commerce Clause jurisdiction.
How do you think this case is going to affect pending cases in the 6th and the 4th circuits? That's another question I've got. Anybody want to?
I can jump in a little on
take
that.
Okay.
Well, sure. So the ones they probably have in mind are the Upstate Forever versus Kinder Morgan case out of the Fourth Circuit. That's the pipeline spill.
Yes, right.
It was petitioned for certiorari at the same time as ours. The court held on to it until it decided ours, and then, you know, not too surprisingly, similar to ours, remanded to the Fourth Circuit. So I've been in contact with the lawyers from the Southern Environmental Law Center, and so that's now back to the Fourth. They're waiting for further instruction. I think it bodes well for that case, particularly if distance traveled and time are the relevant elements. Here you've got a pipeline burst. Everyone acknowledges that is a point source, and that rupture is a point source discharge. And relatively quickly, nearly 400,000 gallons of petroleum products started going towards the tributary headwaters of the Savannah River, unquestionably navigable waters, and traceability is not a problem because petroleum is not a naturally occurring pollutant in those headwaters. And so I think particularly if you're looking at time and distance traveled, I think they're going to be in pretty good shape. The Sixth Circuit cases were the ones that created the split, one out of Kentucky, one out of Tennessee. The Tennessee case has since settled, so I don't really see anything more with that, with fortunately the coal company agreeing to clean up its coal ash ponds. The Kentucky case is continuing under RCRA because the court wasn't going to recognize the Clean Water Act claims. That's an interesting question, if they might be able to revive them in any way in light of this. The other thing I want to point out, as far as like ramifications, I called the tale of two amicus briefs. So a lot of different parties piled on, understandably filing for end of the court briefs in the Supreme Court. One was the Fond du Lac tribe in Minnesota that had been unsuccessful so far in getting a mine to regulate the discharges from its mine tailings ponds that were poisoning areas that were very culturally important for that tribe. And with the Minnesota in the state court system saying that did not require a Clean Water Act permit, that case was pending before the Minnesota Supreme Court. And immediately after our case came down from the Supreme Court, US Supreme Court, both the Minnesota Regulatory Agency and the mine petitioned the Supreme Court to remand voluntarily back to the Minnesota Regulatory Agency so they could reassess that in light of the fact that discharges via groundwater certainly can be covered under the Clean Water Act. So positive ruling for an amicus who weighed in on our side. On the other side of the equation, the Witchmere Beach Club on Cape Cod has filed an amicus brief because they were being subjected to a Clean Water Act claim in the First Circuit due to their wastewater treatment plant that discharged via groundwater directly nutrients into the ocean off Cape Cod. The district court there actually deferred to the EPA's new interpretation articulated last year and dismissed the Clean Water Act claims. It was before the First Circuit. And I think just 2 days ago, the parties in that case petitioned the First Circuit to remand to the district court for entry of a consent decree where the beach club has agreed to clean up its act and get rid of all the nutrients, which I view as just a really positive sign that this case is going to do some good things on the ground for the environment, which is what it's all about.
Okay, I've got just a couple of quick questions. One, it has to do with septic tanks, and we talked about this a little bit, and this is going to go to you again, David. So I'm in a cabin here that's got a septic tank. Your house, you admitted in oral argument, has a septic tank. And one of the questions here is about septic tanks. Do you agree that most Maui homes with septic tanks will not be required to get a Clean Water Act permit? However, some properties on the coastline have transit time under 7 days and distance traveled under 100 feet, and tracer dye tests have confirmed this. So does that change a little bit? And now if an owner of a house with a septic tank now sort of is on notice, has information about this despite the earlier permitting that you talked about?
Well, let's be real clear. I mean, there's any individual case is going to be a fact-specific case. I could just say as a general matter, even if there's a tracer dye study that shows that something going from a septic tank gets into the ocean, that doesn't mean that pollutants get there. Remember, a properly designed septic tank is designed to remove the pollution before it gets to the groundwater, much less migrates into a surface water. Second thing I'd say is, if you have a problem and you are fouling the ocean, let's not argue about whether or not you need a permit. Let's just upgrade your septic system so we stop polluting the ocean. And the third thing is, as the court mentioned, in the unusual cases where a class of activities like this might be causing a problem, the state of Hawaii should issue a general permit to set up the standards so that any incidental de minimis pollution would be covered. And I just got to emphasize, you know, there are states that have general permits about emptying your swimming pool. You know, you can imagine you take a hose, you're emptying your swimming pool. Some of that might get into the neighboring creek, has a little chlorine in it. Technically, that's the addition of a pollutant. These are common day-to-day things that states and 47 of our states administer the Clean Water Act. They just need to adopt standards that people can follow. And if they follow them, then they're covered. No worry, no problem.
Last question, and we may be just a couple minutes over time, but Amanda, I have to ask. You know, we all teach. You teach, Steph and I. We teach regulatory law, and it's often we have this issue about when should the Supreme Court defer to expertise from an agency and when shouldn't it. Here we have a situation where the EPA for 30 years had one position, but then switched it at the last minute, according to one telling. And the Supreme Court actually said, well, we're not going to defer to what the EPA believes in this case because they said they found it unpersuasive, at least Justice Breyer did. Can we make anything more of that? I mean, here is a situation, right, quite frankly, in the Trump administration where a lot of environmental cases and a lot of other regulatory cases are sort of postured in this way where the Trump administration's agencies are taking a position that is different from what the Obama administration agencies had taken. And so there are a lot of flip-flops in this transition of power. Should we read anything into this? Is this the court saying, well, sometimes we'll defer to agencies and sometimes we won't based on whether it looks like there's political flip-flopping, or is this something that is that we can't really draw wide conclusions about?
You're on mute.
Once again, my best guess is that this reflects a compromise among the 6 justices, that there are some who would have deferred to EPA's longstanding position and made an argument that the sort of newly informally adopted position didn't merit deference because it was newly and informally adopted, but that position would not have carried the majority. And so they just all stepped back and said, you know what, let's not even discuss what level of deference is due to which EPA reading of this. So I don't read anything longer term into how the court handled this. I mean, there certainly have been squirrely situations before where agencies have changed position, and there's a famous Rehnquist opinion from the State Farm case noting that an agency changing its mind for reasons of politics is in fact why we have elections, and the new position is entitled to deference. And so I don't think the fact of the flip-flop is the reason for no deference here. I think it's, like I said, probably in part a disagreement among the 6 justices that they just chose not to touch with a 10-foot pole, and in part a recognition that there was a long-standing view that was changed in a very informal way without, you know, a lot of public involvement, et cetera, sort of at the last minute. And so it wasn't even, it didn't even merit the level of deference that the change of position in State Farm would have merited. So I think they just chose not to touch it with a 10-foot pole.
There you go. All right. Well, thank you very much, everyone. Steph Tai, CPR scholar and a professor at University of Wisconsin Law. Amanda Leiter, CPR scholar, professor of American University at the College of Law. Hannah Bernard, executive director and co-founder of Hawaii Wildlife Fund. And David Henkin, staff attorney with Earthjustice in Honolulu. Brian Gum, should I turn it back over to you for closing remarks?
Sure.
I'm just talking about logistics. If there's anything.
Yep, no, that's fine. So a few closing pieces. For those who registered, please watch your email over the next couple of days for a follow-up, which will include a recording of this message or this webinar, as well as ways that you can help share. There'll be some additional resources in there as well. And I just wanted to announce our next webinar, which is next Wednesday. We're doing it in conjunction with Fair Farms. We'll be talking about healthy soils, sustainable agriculture, and just transition. Again, that's June 3rd from 6 to 7:30 p.m. Eastern Time. Thanks so much, and enjoy the rest of your day.
Bye.
Aloha.